will call the Subcommittee number 2 of General Laws to order and ask the clerk to please open the roll for attendance. All right, we have a quorum. I'm going to start off with my own bill. Call my first bill up. Let's see. Number here is 2235, and I'm going to pass the gavel to Delegate Robinson for now.
Thank you, Mr. Chairman. Would you like to present your bill?
Thank you. So I have House Bill 2235. This is a meaty bill. It is an overhaul of a variety of sections relating to common interest communities. Essentially, what the bill does is it simplifies and kind of connects what used to be disclosure packets in various sections of the code. So we had the Condominium Act, the Real Estate Cooperative Act, and the Property Owners Association Act, which all had provisions relating to disclosure packets. These would be packets that are given to prospective purchasers when they enter into a contract to purchase a piece of property in a common interest community in Virginia. And so what the bill before you does is it's really a combination of interests that have come together to streamline this section of the code and take what is trifurcated or put in 3 different parts of the code and put it in a singular new provision of the code called a Resale Disclosure Act. And so this bill has been worked on by a variety of stakeholders. The realtors have been working on this, as well as the the Community Associations Institute, to try to give us something that is more workable, more clear for purchasers of common interest community units. So the main changes in the bill, the main changes in the law, if this bill moves forward, are going to be creating this Resale Disclosure Act in the Property Owners Act in Virginia. And so main pieces of this bill that we've changed are that the disclosure packet is now renamed as a resale certificate. Now, the old disclosure packets had a variety of disclosures that the code required be given to any prospective purchaser. And what we have done is require every one of those provisions in the new Resale Disclosure Act. There are no previous disclosures that have been in the code that we eliminated. And so all the protections that other delegates and senators have put in the past are still going to be in the code under the new bill. Some other things that have done. We've called for the resale certificate to be a standardized format and be worked on by DPOR. And so they will be creating a standard form to be used across all of these common interest communities under the bill. We've changed, there were some issues, and there has been issues in a variety of cases where there were different timing dates, calendar days versus business days in these various provisions of the code. And so we have amended the Resale Disclosure Act to define the days as calendar days. We have added a couple additional disclosures in the bill that would include parking and vehicle restrictions, restrictions on certain home-based businesses, rental restrictions, and more notice about any encumbrances that may pass with the land to any prospective purchaser. And additionally, we also eliminated professionally managed and self-managed association distinctions in the statute. I know this is a long bill, and so there's a substitute, and I would entertain a motion on the substitute. All right. Substitutes before us. That might have been Delegate Robinson's job, but we're moving on through this.
So all in favor of adopting the substitute, say aye.
Aye.
Anyone opposed? Is there anyone in the audience who wants to speak, or any members of the committee who have a question? All right, anyone in the audience who wants to speak in favor of the bill?
Yes, Erin Corman with the Realtors. Want to thank the delegate for carrying this bill for us. There is peace in the valley. We've worked for many months with the stakeholders to get to this place. I know the bill looks long. A lot of it is just fixing cross-references from the 3 sections that we struck. But I'm happy to answer any questions if anyone has any. Okay, thank you.
Next.
Madam Chair, Pia Trigiani, representing Community Associations Institute. I can't remember who I am today. Thank the delegate for carrying the bill, and also would like to join Ms. Barton Corman in her remarks, but correct her on one thing. It was years, not months, that it took to develop this legislation. Thank you.
Thank you.
Madam Chair.
Delegate Boulevard.
Just because it's Pia Trigiani, I got to ask her a question. No, and I think it's a friendly question. I just want to make doubly sure because Chairman Wampler, I think, did a great job of going over, I think, what was my first big concern is the disclosure is transferred over pretty seamlessly, and that there's nothing in there that got lost in translation. The other area that I know is important is what happens if you don't get a complete or accurate disclosure package or resale certificate, and I guess the rights and responsibilities of the different parties if that was to occur. And so can you tell us if anything has changed in that regard?
There are no changes. In fact, we clarified that you still have a 3-day right of rescission unless by contract you agree to extend it to 7 days. There is case law which this codifies about incomplete packets. It's if you don't get it, it does not break down into individual statements. So there's no change in the law with respect to. We did, as Delegate Wampler described, tried to consolidate all 3 statutes, which we have over the years tried to maintain as parallel. And one of the reasons it's been a challenge is because it was in 3 places. But now in this one place, we'll be able to do that. But we didn't change any purchasers' rights. And in fact, the ability to charge and receive payment up front is a tremendously positive change, as well as standardizing the form for these certificates for resale. There's been a problem in the quality and content of them, and this is something that the realtors and the Institute have agreed upon for a long time. So it's a good change. Thank you.
Thank you very much.
All right. Is there anyone in the audience who wants to speak in opposition to this bill? Seeing none. We act on a motion. All right. It's been moved to report the substitute and seconded.
Yep.
Well, Delegate Wampler, bill passes on an 8-0 vote. And I turn the gavel back to you.
Thank you, Your Highness. Next, we'll take up, let's see, House Bill 1930. That's Delegate Runyon. Come forward. Tell us what your bill
Thank you all.
does.
Excellent chair, as going in and Madam's arena. And members of the committee, thank you all. I've got a really quick bill that's interesting. So Virginia storage facilities store watercraft as we do many other things, but unlike 40 states that do not or that allow watercraft storage, our state does not allow towing if you stop paying the bill. And what really happens is if you've got a boat, as many of us have experienced that is worth nothing, you take it to a rental storage place, you stop paying the bill, they're stuck with the disposal of something that's not worth the residual value. So it's kind of a sneaky way to get out of your responsibility. Other states allow for that boat to be towed as you would other items like automobiles by a towing company. So after 60 days, the boat would be towed to a towing yard that would be stored, and then they'd go through the normal process of getting rid of the product. And so, sorry, I got a little tongue-tied there. Gives the storage owners an alternate remedy, because what happens is they're trying to rent space, and this boat that's not generating any revenue takes up the space. So this gives them an opportunity to be able to get rid of that. I think it is important to note the same protections that service members have for all of these type cases are included in this. So if someone gets deployed and something gets messed up on their payments and all, those folks are protected. Happy to answer any questions.
Any questions from the committee? Delegate Murphy.
How do I do this? Is this working? I'm not understanding the difference between the two places that the boat would go. One is a storage facility and the other's a storage facility.
Well, the other one is a towing facility, and they have certain rights for disposition of assets that they tow into their yards. And there's a process that they go through. You may have seen, they advertise, they have a public auction, people come in and buy, they can dispose of salvage, based on a salvage rights.
Okay.
The storage yard does not have the ability to do that.
Okay. Thank you.
Is how I understand it. I'm happy to, I have someone here that may not phone a friend as we've been.
We'll take public testimony here in a minute. Is there any other questions from members of the committee? Seeing none, all those in favor of the bill, come forward and tell us your position.
Thank you, Mr. Chairman, members of the committee. David Halleck on behalf of the Virginia Self-Storage Association. We appreciate the delegate introducing the bill. He explained it better than I could explain it, so I'm happy to answer any questions, but don't want to encroach upon your time.
Is there anyone here to speak in opposition to the bill? Seeing none, you have the final word on yard boats and storage units.
Hey, appreciate it. Thank you all.
All right, committee acts by motion.
Second.
It's been a motion and second to report. I would ask the clerk, please open the roll for a vote. Delegate Carr, would you like to cast your vote? All right, Delegate Runyon, your bill reports 8-0. Good luck with the yard boats. Next up, we will take Delegate Buliva's House Bill 1635. Please feel free to present from the dais.
Right. Thank you very much, Mr. Chairman, members of the subcommittee, and I appreciate you letting me explain this bill. I can't believe it was 2 weeks ago already. Before we went ahead and passed it by, so we could go ahead and work out some details with the stakeholders to make sure that everyone could be supportive of the solution. I do want to thank all the stakeholders for getting together and doing just that. So these were very productive conversations, and I believe the substitute that we have before you today addresses all their concerns. And so at appropriate time, Mr. Chairman, if we can get the substitute before us.
Mr. Chairman, I move the substitute.
Is there a second?
I'll second.
All right, motion seconded, the substitute. All those in favor say aye. Any opposed? All right, the substitute is properly before us. Will you tell us what the changes were in the substitute, Delegate Bulba?
Yep. No, thank you, Mr. Chairman. So if you'll recall, this bill just makes sure that when a tenant first accepts the keys to their rental unit, that at the very minimum, it should meet basic habitability standards, or else they should be able to go ahead and get out of the lease and get their deposit back. Those habitability standards have been worked out over the years with this committee as well as the different stakeholders, and the language in here is identical verbatim to those other sections of the code. The two primary differences between the bill you saw 2 weeks ago and the substitute, one is to increase the time that the landlord has to refund the security deposit. So that's from 7 days to 7 business days. The stakeholders felt that was a reasonable amount of time to move things through the system. The more substantive change was dealing with the process for a landlord to challenge a tenant's assertion regarding habitability. And so in the original version, if a landlord disagreed with the tenant's assertion, the landlord then had to go to court after providing written notice. And if the landlord won, then they could collect reasonable attorney fees. That actually presents some risk to the tenant who might make an assertion, not understanding where the landlord might stand or in terms of what their pushback might be. And so what this does is if the landlord disagrees, they would provide that rationale to the tenant in writing, and then it would be up to the tenant to go ahead and decide whether they wanted to go ahead and take it to court with, again, their eyes wide open in terms of what they might be facing as they're going in for doing that. And so I think those are two really good improvements to the bill. I think it makes it work much better. And again, appreciate the stakeholders' work to pull this all together.
Thank you, Delegate Bulova. And for the committee, we also have a singular line amendment, which I would offer to to council. We are going to insert the prevailing party on line 33 of the bill. After the word "and," before the word "shall." And as part of that amendment, also strike "from the landlord" in line 34. I would ask for a motion on that amendment.
So moved.
Second.
All right, it's been moved and seconded. All those in favor of that amendment, please say aye.
Aye.
Any opposed? All right, that amendment is now a part of your substitute. Is there anyone here to speak in favor of this bill? Please come forward.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We thank Delegate Bulabov with coming forward with this issue with us to make sure everybody has a fit and habitable home to live in. So we ask that you support the bill. Thank you.
Hello, Chair, members of the committee. My name is Gustavo Espinosa. I'm with the Legal Aid Justice Center, and we support this bill. We get calls regularly from tenants that didn't get an opportunity to see the unit they were moving into. They saw an identical unit, and when they moved in, it wasn't habitable. And right now, there aren't many remedies that a tenant can use, and so we urge you to support this bill. Thank you.
Mr. Chairman, members of the subcommittee, Christy Mara with the Virginia Poverty Law Center. For all the reasons previously stated, we support the bill in its amended form and with the amendment that the chair just added, which, as I understand it, makes the attorney's fees provision reciprocal.
Erin Corman with the Realtors. Just want to thank the delegate for bringing this to us and listening to all of our concerns, and we support the bill.
Good afternoon, Taye Mallory with the Virginia NAACP. The Housing Committee supports the bill. Thank you.
Is there anyone here in opposition to the bill? All right, seeing none, it's back before the committee.
Mr. Chairman, report the substitute as amended.
It's been motioned and seconded to report this bill, the substitute, as amended. I would ask the clerk to please open the roll for a vote.
Mr. Chair.
Delegate Coiner, please destroy the roll.
I'm sorry. I just want to make sure with the substitute, since I was just reading the substitute for the first time, that I'm clear. So if the tenant gives notice to the landlord, they want their money back because it's uninhabitable. And the landlord must do that unless in the next section the landlord gives notice in written notice to the tenant that he refuses the termination, and the landlord gives reasons for it. And after the tenant gets that, the only remedy left would be if the tenant went to court. That's correct? That's the new process in the substitute? Okay.
Mr. Chairman, yes.
All right, Delegate Coiner, any further questions? All right, it's been motioned and seconded to report the substitute as amended. I would ask the clerk to please open the roll for a vote. All right, that bill reports 7-1. Delegate Bulva, congratulations. Next up, we'll take House Bill 1955. Delegate Tata, please come forward. Tell us about your bill and what it does.
Thank you, Mr. Chairman and members of the committee. HB 1955 is a bill that came to me on behalf of the American Resort Development Association, and it deals with a technical change regarding disclosure requirements related to timeshares. It simply moves a disclosure requirement concerning the sale of alternative purchases from one document over to another. Virginia law states that an alternative purchase is not a timeshare. This bill moves that the disclosure of whether a developer will offer these vacation packages from one document that is recorded in a locality's land records called the timeshare instrument over to another document called the public offering statement. The public offering statement is given to the timeshare purchaser before closing and provides the details about the timeshare program. Since an alternative purchase is not a timeshare, it makes more sense to have the disclosure in the public offering statement. For clarification, alternative purchases are essentially vacation packages at the resort offered to those who choose not to purchase a timeshare but are still interested in staying in the property later. These products must be registered with the Common Interest Community Board, and this bill does not change that. The bill is consistent with how other states with multiple timeshares handle these disclosures. So again, basically, this bill makes a technical change and moves a disclosure requirement about whether a developer will offer alternative purchases from one document that is difficult to amend to another document that is easier to amend. I have subject matter experts here if you have any questions.
Thank you, Delegate Tata. Is there any questions from members of the committee at this time? All right, anyone here to speak in favor of the bill?
Mr. Chairman, Chris Nolan with McGuire Woods on behalf of the American Resort Development Association, and want to thank Delegate Tata for carrying the bill. We support it, do view it as a technical change, and happy to answer any questions if there are any. Thank you.
Is there anyone here to speak in opposition to the bill? All right, seeing none, it's back to the committee.
Move report.
Second.
It's been moved and seconded to report House Bill 1955. I'd ask the clerk to open the roll for the vote. Thank you, Delegate Tata. That bill reports 8-0. You will not need to be in full.
Thank you very much.
Next up, let's do Delegate Williams-Graves, House Bill 1614.
Thank you, Mr. Chair and members of the committee. House Bill 1614 does have a substitute.
It's been moved and seconded for the substitute. All those in favor say aye.
Aye.
Any opposed? All right, substitutes before us. Tell us what your bill does and what your substitute does.
Thank you so much. The bill supports stable and affordable pet inclusive housing and protects the bond between people and their pets. It will require Virginia's housing redevelopment authorities to allow residents to keep pets. It also directs these entities to implement pet inclusive policies that are free from breed or weight restrictions, and it will prohibit limiting the number of pets a family can have beyond what the local code already states. The availability of pet inclusive affordable housing is a major barrier for a lot of people, despite the fact that 3/4 of renters are pet owners. Between the combination of a lack of pet-friendly housing overall and expensive or restrictive provisions within what is available, low-income families are most disproportionately affected. Pets are part of our families, and the family unit should be protected. The fix to this is an increase in the availability of pet-inclusive affordable housing by prohibiting arbitrary restrictions such as breed restrictions and weight limits, stronger protections for companion animals and the people who love them begin with the government, which is why this bill focuses on Virginia's Housing and Redevelopment Authority. Lastly, I will also say that giving public housing residents the ability to have pets will also allow them to foster pets, and it will also help with savings in taxpayer dollars because it will get pets out of shelters. And we do have folks here to speak on the matter.
Sure. Delegate, who brought you this bill? Was this something that you came up with, or was this a housing authority that brought this forward?
No, actually, it's a group of pet-friendly folks that are constituents of mine that I have worked with over the years, and they brought me this bill.
Thank you. Are there any questions from members of the committee? Delegate Fowler.
And again, I'm probably the biggest pet lover and dog. You know, the only concern I have is it says one or more, which again, you know, so clearly that's undefined, the number of pets that the tenant might have. So I don't know if perhaps that might be problematic. So I'll just, you know, throw that out there, you know.
All right. Any other questions, statements? All right. Anyone here to speak in favor of the bill? Please come forward.
Thank you. Good afternoon, members of the subcommittee. Mr. Chair, my name is Molly Armis, and I am the Humane Society of the United States Virginia State Director. On behalf of the HSUS and our Virginia supporters, I'm here to testify in support of House Bill 1614. I do want to note that in response to Delegate Fowler's question, the new substitute does not establish any pet limit at all, so the housing authorities are still free to say that they can only have 2 pets or only could have 1 pet. So there's still, I believe the substitute says that. So they can establish a pet limit as part of their pet policies.
Okay, because I haven't seen the substitute. Thank you.
Yeah, no problem.
Members, if you will check LIS for the substitute, it has posted.
But, you know, Delegate Williams-Graves did a great job just explaining, you know, why this is important. And one of the things I do want to note is that, you know, it's obviously no surprise with housing insecurity for people, that one of the top reasons pets are relinquished to animal shelters is due to housing problems. And again, it is due to these arbitrary restrictions. And we have searched long and hard for the study, the science, the definitive work that told, the housing industry which breeds are acceptable, which pose a higher risk, and what weight separates a suitable apartment dog from those that are hazards. We really haven't found any scientific basis supporting the notion that any breed of dog is more dangerous or aggressive than another, or that there is a perfect apartment-sized dog. Again, we just are asking that they're not excluded based solely on these misperceptions based on how they look. Again, there's broad authority within this bill for the public housing authorities to implement policies that apply to all pets. So we ask that you please support the bill.
Thank you.
That tightened it up a little bit.
Mr. Chairman and members of the committee, my name is Tabitha Treelor. I'm with the Richmond SPCA. We are a member of the Virginia Federation of Humane Societies, and I also speak for that membership organization. Virginia Code Section 3.2-6541.1 expressly prohibits localities from banning ownership of a particular breed, recognizing that breed-specific legislation does not create a safer community. Yet our public housing authorities adopt breed restrictions either explicitly or by putting severe limits on weight, which serves as a de facto breed restriction. More than half of dogs in American homes are mixed or unknown breed, so these policies rely on physical appearances to make life-altering decisions about a tenant's family member. Federation members around the state have dealt with situations where people are devastated to relinquish an animal due to a housing or landlord situation. One shelter in Northwest Virginia reported in 2022 that 46% of relinquishments were due to housing issues. And another VFHS member in Southwest Virginia has experienced more than 100 calls a month last year from guardians who were struggling to maintain their pets, and housing is also cited there as a primary reason. And they noted that if housing did allow pets, they had to be small dogs, could not be bullies or bully mixes. There's no evidence that indicates that a dog behavior is predicted by their outward physical characteristics, and these arbitrary policies most affect those who have limited choices about where they live and how much they pay for rent. And regardless of income, we hope that you will agree that Virginians should be able to decide what their families look like, and pets are family. So we ask that you support this bill. Thank you.
Thank you. Is there anyone here in opposition to the bill?
Hi, Mr. Chairman. Troy Garrett with the Virginia Association of Housing and Community Development Officials. We'd like to thank the patron for working with us and with the other stakeholders. Unfortunately, there was one sticking point in the bill that we could not get past, and that was the weight restrictions. It's just simply that there are some facilities, including high-rises and very small units, that are just not capable of handling a large dog, regardless of the breed. We would be happy to work with the patron if we could find something, but as of right now, we cannot support the bill without the weight restriction.
Thank you.
Thank you.
Anyone else? All right, the bill is back to you. Delegate Graves, you have Delegate Bulova has a question for you.
Mr. Chairman, I guess my question, and then I'll make a motion if appropriate, is sounds like the bill is really close to being ready for prime time with that one sticking point in terms of weight limits. And I can understand where in certain circumstances you might want to allow an authority to go ahead and do that based on the location and the nature of the apartment. And so I'm going to go ahead and offer what I hope is a friendly amendment that will allow for an authority to go ahead and regulate, I guess, over 35 pounds for a companion animal. And I'm not quite sure how we'd go ahead and do that for council, but if we'd be able to go ahead and craft some language that allows them to go ahead and do that, I think that'll help to go ahead and get this bill over the finish line.
Mr. Chair, I would see that as a friendly amendment.
Do you have language to that extent?
Do we have language? Do you guys have?
All right.
Can we take a pause and come back?
Mr. Chair, I have a motion at the appropriate
Delegate
time.
Coiner.
Mr. Chair, I would move to gently lay this bill on the table.
It's been a motion to lay this bill on the table, and second, I would ask the clerk to open the roll. Delegate, good luck. Try to make it permissive, not mandatory next time.
It is permissive, but thank you.
That bill is gently laid on the table on a 5-3 vote. Next up, we'll take, let's see, Delegate Maldonado, your House Bill 2022. Please come forward and tell us what your bill does.
Thank you, Mr. Chair. Good afternoon. Good afternoon, members of the committee. I have an amendment in the nature of a substitute.
Is there a motion on the substitute? It's been moved.
Second.
And seconded on the substitute. All those in favor say aye.
Aye.
Any opposed? All right, substitutes before us. Tell us what your original bill did and what your substitute does.
Yes, thank you, Mr. Chair. So this bill, HB 2022, is meant to close a little bit of a loophole that we discovered over the last several months, where we were finding that our tenants, particularly in our low-income housing, were experiencing landlords who were increasing the rent in the middle of the lease term. And these are tenants who are least able to afford those increases. They are teachers' aides, paramedics, first-line workers, and they're coming home and seeing Post-it notes, for example, on their door saying the rent is going to increase $100, $150, $200 the next month, and the next month could be 2 weeks away. So the intention with the original bill, what we did was had a strict sort of prohibition on having these kinds of clauses, but then said, of course, there may be valid reasons where a tenant and a landlord may, in fact, want to increase the rent during the lease term. So we allowed for that, of course, in a separate instrument, a separate amendment that was agreed to and signed by both parties. The substitute, the amendment in the nature of the substitute, goes a step further and limits the application of this to lease terms of 12 months or less, because there are some instances where there are multi-year leases. So we don't want to hamstring our landlords, but we want to make sure that our tenants are covered and can budget properly, particularly in the lower income and workforce areas. So the substitute limits it to 12 or less months, and it also delays the enactment. We want to give landlords a bit of time to sort of come into compliance. So instead of being active on July 1st, 2023, it would come into effect on January 1, 2024, and would, of course, apply to rental agreements that are entered into or renewed on or after that date.
Thank you, Delegate. Not seeing any questions from the committee. Is there anyone here to speak in favor of the bill?
Hello, Chairman, members of the committee. My name is Gustavo. I'm with the Legal Aid Justice Center. And as a tenant organizer, I work closely with hundreds of tenants. And lately, I've been witnessing tenants with this kind of special provision in their lease. I even brought a copy today. And that means that I've seen tenants with rent increases $100 to $200 in the middle of their lease term, meaning outside of the renewal process, with no chance to negotiate, without a chance to decide if they want to stay or leave. It's simply unfair. How do you feel your constituents would feel if they received a 20% rent increase in the middle of their term without their say-so? And lastly, I wanted to add that last week, a tenant that I'm working closely with drove down from Charlottesville to testify on this bill in the Senate for the companion, where it passed unanimously and in a bipartisan way. And so I'm asking that the same thing happen today. I see no reason why it shouldn't. Thank you.
Mr. Chairman, members of the subcommittee, Christy Marrow with the Virginia Poverty Law Center, and we want to thank the delegate for bringing this bill and for working with all the stakeholders. We do strongly support the bill for all the reasons stated by the previous speaker. Thank you.
Mr. Chairman, Erin Corman with the Realtors, and we also support the bill.
Mr. Chair, Brian Kozu with the Virginia Housing Alliance. We also support the bill.
Mr. Chair, Talia Mallory with the Virginia NAACP, and we support the bill.
Mr. Chair, Isabel McLean with Housing Opportunities Made Equal of Virginia, and we support the bill.
Randy Grumbine, representing the Virginia Manufactured Modular Housing Association. We too support the bill.
Anyone here in opposition to the bill?
Mr. Chairman, I have a question.
Delegate Robinson.
So, just for clarification purposes, so the person is living in the apartment already. They've already signed some type of lease, so they've already had a contract with the landlord, and now the landlord comes to him and says, "I'm going to raise your rent," right? And the landlord and the tenant says, "Okay, sure." And they're going to have to sign a document that says they're in agreement to that, which will supersede, I guess, or whatever, the lease that they currently have. And if they don't do it, what happens? Or maybe I don't have this right in my head.
Thank you for the question, Mr. Chair. I would say to the delegate that in any contract, if you want to change the terms, you do that through a written instrument, an amendment, and this would be the same thing. What happens is in some contracts, there are these escalation clauses, and it catches people off guard. They're not able to accommodate. So we want to help sort of balance the playing field. So if a situation were to arise where a landlord did want to increase the rent and the tenant agreed, they would sign an amendment increasing the rent for whatever additional portion or to change the entire rental amount. But that would be by mutual agreement, which is what it should be when you are engaging in these kinds of contracts.
Mr. Chair, I have a question.
Delegate Coiner.
So if you have your original contract and the contract in it says your rent shall be $100 for the first 3 months and then $115 for the next 3 months, and we'll call it 9 months, and you add $15, and then you all sign it, that will no longer be sufficient. You would have to have one contract for your original $100, and then you want them to sign a separate agreement for any increases.
No, what I would say, thank you for the question, Mr. Chair. What I'd say to the delegate is that what we're looking to do is have a streamlined amount of rent. And if during the term, so 12 months, so for example, if you have a 6-month contract, that's a different amount. If you have a 12-month contract, there would be an amount. I have never seen a case where in a 12-month or a 6-month or a 3-month contract where you would have different amounts during that time spelled out. It is possible, I suspect, but that isn't typically how the landlord-tenant agreements work. What I would say is that the intention is for people to understand what their rent is going to be and to be able to properly budget around that. And if they want to increase the rent outside of that 12-month term or less, then you would have to go by a mutual agreement.
Mr. Chair.
Delegate Coiner, follow up.
I guess I'm still not clear. So you sign a 9-month lease, and it says what your rent is.
Yes.
So if the landlord, any time during those 9 months, if there isn't an escalation clause, doesn't have the right to increase it, you can go to court to enforce the terms of your lease.
Correct.
So I'm trying to understand the problem, because if your lease has an escalation clause, then you've been made aware of it, and then landlord has a right to increase it under your contract. So how is that not disclosure of what's the need for a separate instrument? I'm trying to understand the problem.
Yes. Thank you for the question. Mr. Chair, I would say to the delegate that where this is impacting the most profound people are those in our lower income communities. So our teachers, aides, paramedics, first line workers, people working 2 jobs, double shifts. And yes, in those our lower income sort of housing lease agreements, there may be escalation clauses. But think about people in those, in the context, the bigger context of what's happening in our housing community and the affordability issues that we're experiencing and the compression of inventory. So you may have to take an agreement because you don't have a place for your family to live. So if your low rent, your housing is telling you, here we have a place for you, But by the way, we're going to increase it if we want to when we want. It almost is an unequal bargaining power, and it exacerbates an already difficult problem with some of our tenants who aren't in a best position to be able to afford any of the escalations. So yes, it's in there, but let's also look at practicality, that most people don't carefully read those lease agreements, and so we have situations where people are caught off guard. All we're trying to do is level the playing field to those who are least able to afford increases and who are among the most vulnerable, that they aren't the ones shouldering the responsibility. Now, one thing I will also add is that some people will argue that in some of these lease agreements that these tenants are paying for gas and utilities. That is not uniform. It is not always the case. And in many, when the rent increases like this, they are also trying to accommodate that along with paying for those additional expenses.
Thank you, Delegate. I tell all my clients from all walks, read your contracts every time. We have some other questions from the committee. Delegate Brewer.
Thank you, Mr. Chair. Delegate Maldonado, so in parts of the state that are pretty competitive for housing, for instance, I see a lot in Hampton Roads, especially when we have a lot of shifting of military communities. A lot of apartment communities are doing specials or sales, or it's like $200 off the first 3 months, or something cutesy where there is during that contract, and they put that in there that they are to have a certain amount off for the $100 here, $200 there. Would that apply to that? I'm assuming it would, but like if someone signed a contract where the first 3 months were $200 off, and then that's considered an escalation, right?
So in that circumstance, thank you for the question, Mr. Chair. What I'd say to the delegate is if you sign a contract and they're giving a discount to incentivize you to enter into the agreement, I would not consider that something that falls into then requiring a second contract. I am open, if you think that is captured in the way, prevented in the way we drafted it, I'm open to a friendly amendment. But certainly when you sign and say your first rent is going to be $200 less, thank you, and then everything else is going to be, why?
I'm not attempting amendment, but Mr. Chair, maybe we can ask council, would a situation like that apply? That's all I'm asking.
I'm not sure that one's for council. We'll just keep it between the delegate and the committee for now. Are there any other questions? Delegate Robinson.
Yes, Mr. Chairman, I have another question. So they get the notice, and I'm going back to my original question. They get the notice, and they say, I can't afford this, right? Now everybody's in trouble, right? Because the landlord doesn't have his rent, he can't raise it because they're not going to be able to pay it. The tenant would have to, I guess, choose to then be not in that contract. I mean, they're then breaking the original lease contract with the landlord. So I'm not sure I understand what would happen at that point in time because the landlord is now saying, and I don't agree that the landlord should just be randomly able to do it, but if it's in the contract already or they've signed that lease already, they're on the hook, right? I mean, that's what a contract is about. So can you address that concern?
Absolutely. Thank you for the question. Mr. Chair, what I would say to the delegate is that is the very issue that we're trying to address. There are social sort of policy issues about why we wouldn't want to have contracts entered into that disproportionately and adversely impact our lower income populations and those who are the most vulnerable and the least capable of paying for these. And when we allow for those kinds of contracts to enter into, it creates a ripple effect across our housing affordability community and issues. And I would also offer that there is not a person from a sort of a concept part would agree that somebody should just be able to unilaterally do that. And part of the requests that we're hearing, the cries that we're hearing, the problems that people are experiencing about how do I keep a roof over my family's house has to do with whether I can count on as a tenant that my rental amount is going to stay at a place where I can afford it until the next renewal period. There's no way to project, to plan, to budget properly if there are ways to increase it that are outside of the timeline of the lease term. And to me, it's an issue that is ripe for us to prepare and represent to the people who are most affected.
Mr. Chairman, I have a motion.
Delegate Robinson. Oh, we have another question from Delegate Bulova. Maybe a statement. Delegate Bulova.
It's maybe a statement and a question, but I totally understand what you're trying to get, and I think this got what Chairwoman Robinson was talking about. If you've got somebody who has a large unanticipated increase halfway through their lease, you are setting up both parties for potential failure, right? And that helps exacerbate and contribute to the eviction problem. And so I think it's an issue that we need to address. I wanted to kind of follow up on what Delegate Coiner was asking, because I'm not aware that typically you have a 12-month or less lease, where you have a stair-stepped, clause in there. I think what you're worried mostly about are kind of your wide open opportunities to go ahead and increase, based on X, Y, and Z factors, which would, somebody wouldn't know what they were getting into ahead of time. And so, thinking through that, I could easily see a way to go ahead and make a small amendment in here, on line 31, so instead of saying any increase, we're talking an indeterminate increase. Those, if you say, hey, on month one, you're going to pay $200 and you're going to pay $225 and then $230, you have that in black and white in front of you. What we want to avoid are those surprise increases where you're like, I can't afford that, and it throws everybody into a bad situation. And so I'm mostly trying to get a sense from the patron whether she would be open to something like that. So you're narrowing this down to indeterminate amounts in a contract and saying, hey, you shouldn't be able to go ahead and do that because it places everybody in a bad situation.
Thank you, Delegate Bulova. I'll just offer this. We've considered another one of your measures this session that dealt with automatic renewal provisions and the notice that needs to be given to tenants if there's going to be a rent increase between those the tenancy term. And so we've already helped provide some protection for increases in rent. And thank you for your work on this. It seems like, given the risks that are out there, it may be appropriate to keep trying to tackle this in the future and bring a bill back that doesn't necessarily weigh so much on how people can contract, freedom of contract. That's a principle of law in Virginia that we respect very highly. And so with that, I would entertain a motion to gently lay this on the table.
So moved, Mr. Chairman.
Second. Thank you.
It's been motioned and seconded to lay this bill on the table. I'd ask the clerk to open the roll for a vote. Thank you, Delegate. That bill is laid on the table 5-3.
Thank you.
Next up, we have Delegate Munden King, House Bill 2082. Please come forward.
Thank you, Mr. Chair and members of the committee. House Bill 2082 is a bill to protect Virginians living in apartments by codifying practices related to background checks and the storage and management of electronic keys in apartment communities. So this bill will require screenings for any employees who enter into an apartment home to have a background check. And it will also require apartment complexes to develop written policies for the handling of master keys, including electronic keys. This committee graciously referred this bill last year, and I was very grateful. We didn't make it across the finish line, but it was inspired by the story of 19-year-old Mia Marcano, who was tragically murdered by someone who worked at her apartment complex and used a master key to enter the apartment and wait for her to come home. We've done a lot of work on this bill with apartment industry, with realtors and others to ensure that we are not creating any undue burden to businesses, but simply we don't want any other family to experience what the Marcano family experienced due to unfettered access to apartments. Thank you, Mr. Chair.
Thank you, Delegate. Any questions from the committee?
Delegate Munden King.
Delegate Robinson.
My question only is to do no harm other than just to say, so what did you change from last year to this year?
So we didn't make a change from last year to this year. I, in my very junior state, had a lot of requirements initially, and I worked with both the apartments and the realtors to understand what the current policies are and to have this reflect sort of national business practices.
All right. No other questions in the committee that I see. Anybody here to speak in favor of the bill, please come forward.
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert, representing the Virginia Apartment Management Association, as well on behalf of our sister organization, the Apartment and Office Building Association of Metropolitan Washington. We greatly appreciate the patron for working with us on this bill, and we urge you to support it.
All right. Anyone here to speak in opposition to the bill? All right. We have a few electronic participants in the queue, I believe. Ms. Regina, can you call the first witness?
We have Jody Lewis.
Ms. Lewis, if you could unmute and please provide your testimony. Keep it brief and tell us if you're in support or opposition to the bill.
Absolutely. My name is Jody Lewis. Thank you for having me. I am one of the founding members of the Mia Marcano Foundation and work very closely with the family in terms of the entire incident, and then onward to work with the family to get Mia's Law, what has been coined in the state of Florida, passed successfully. Governor DeSantis signed that bill in June of 2022, and it became law January 1 recently. So this particular law we've worked very hard at in the state of Florida, and I can tell you that restricting unfettered access and increasing background checks and making apartment complex actually keep log systems of who is going in and out of apartments. These things, if they were done, Mia Marcano would still be alive today. It is very unfortunate that we have evil people in this world, but these types of laws are put in place to help prevent these types of incidents from happening. So I 100% support this law, and I came here today to say that not only me, but a whole heap of people in Florida did as well, and it passed unanimously in the state of Florida as well. So we are here to support Delegate King and her efforts. I don't want to take up too much time, but I appreciate you guys having me here, and hopefully we'll be able to share more of how what happened to Mia impacted not just her family, but an entire community, and the amount of stories we, through the foundation, have received phone calls and emails of tenants and residents that have experienced similar situations where workers have come into their apartments without work orders, and they've tried to report certain things and they get evicted, or those things go in their record. It's some horrible stories that we're hearing around the country. So we're trying to do our due diligence to make sure that, you know, legislators like yourself are informed and know and can help us with these efforts.
Thank you for your testimony, Ms. Lewis. I'd ask the next witness that's with us on the online queue if you could state your position.
Hi, good afternoon, Chair. Good afternoon, panel. My name is Ema Scarbriel, and I am Mia Marcano's mom, and I support this bill. I support this bill for the mere fact that, unfortunately, it wasn't in place to prevent my daughter from being murdered by a maintenance worker who had unfettered access to my daughter's apartment. We know he used his master key fob and went into her apartment and waited 30 minutes before she got off of work. So in this bill, I'm asking that you do take it into consideration to at least another family will never have to go through what we're going through currently with our daughter. Thank you.
Thank you very much. Are there any other speakers in the online queue?
No, Mr. Chair.
Okay, so back to the committee. Any questions? Delegate Munden King, you have the final word.
Thank you all so much for considering this, and thank you for your time. And I just want to say thank you, to the Marcano family for being brave enough to share their story today.
Delegate Munden King, I have a quick question for you. So your bill in line 20 and 21 says that an applicant has to have a pre-employment criminal history check, but doesn't require a landlord to do anything if they do, have a negative, or a adverse criminal history check. Is that, you just want them to make sure that they're screening the folks who have access to the keys to the apartment under this bill? Is that right?
Absolutely.
To help them make an informed decision?
Informed decision, and that was one of the changes that I made.
Understood. All right, bills before the committee.
Move to report.
It's been motioned and seconded to report House Bill 2082. Clerk, please open the roll for a vote.
Mr. Chair.
Delegate, I'd ask the clerk to close.
No, it's fine. Sorry.
All right, questions withdrawn. The bill reports 6-2. Delegate, thank you.
Thank you so much.
All right. Seeing a few of our patrons not here, let's take up Delegate Carr's bill. Let's start with 2045. Please present from wherever you're comfortable.
Thank you, Mr. Chairman. There's a very short amendment to 2045.
It's been motioned and seconded to move the amendment. Is all in favor, say aye. Aye. Any opposed? All right, amendments in front of us. Delegate, tell us what your bill does, and if the clerk would report the line amendment. Excuse me, council, report the line amendment.
Yes, Mr. Chairman, on line 91, after modular, comma, insert manufactured, comma.
All right. Go ahead,
Thank you,
Delegate
Mr.
Carr.
Chairman. HB 2045, this bill would implement a recommendation from a 2021 JLARC study of the state's affordable housing needs. It creates a new program at DHCD to provide financial incentives for localities that modify their zoning ordinances to facilitate the development of a more affordable housing. It's been widely recognized that local zoning ordinances restrict housing supply. The JLARC study reports that the most common obstacles to more affordable housing identified by local planners are construction cost, supply of land, the cost of land, infrastructure capacity, and public opposition. Zoning changes could help mitigate each one of those challenges. JLARC pointed out that zoning is not only a major housing supply constraint statewide, and so a statewide mandate regarding zoning practices would not be appropriate or feasible. A better approach would be to provide additional state funding to localities that voluntarily take the initiative to modify their zoning ordinances to facilitate more affordable housing. To most effectively incentivize localities to make zoning changes, the bill provides that the funding from the incentive program could be used by localities in a variety of ways and not just for affordable housing initiatives. The allowable uses of the funding are set forth starting on line 109 of the bill, and they are very similar to the allowable uses for proffers that some localities receive from developers. Through this program, for example, if a locality set aside some portion of its land for affordable housing and modified the zoning requirements for that land to ensure that it could be used to build more affordable housing, that locality would be eligible for funding from this new state incentive program. The locality could use the incentive funds to meet some of their existing needs, such as the new firehouse they want to develop or upgrading water and sewer infrastructure. The program would be administered by DHCD, and the bill calls for DHCD to report annually on how effective the program has been. The program has a sunset date on July 1, 2029 to enable General Assembly to assess the effectiveness of the program at facilitating the development of affordable housing. And, Mr. Chairman, I believe there are folks from JLARC here to answer if there are technical questions.
Mr. Chair.
Delegate Corner.
This is a great bill. I doubt there's anybody here in opposition. I would, if there's no one here in opposition, move to report and refer to appropriations.
All right, let's hold on that motion just real quick. Any other questions from members of the committee? Okay, those in favor of the bill, if you'd like to come forward, state your position.
All right, I'll go first. Thank you, Mr. Chair. I'm Isabel McLean with Housing Opportunities Made Equal of Virginia, and we support this bill because it will encourage the revision of zoning laws in Virginia that restrict housing opportunities and affordability. For far too long, various zoning regulations have been a barrier for many Virginians as they seek to establish a home, find community, access resources that they need, amenities they need, and provide a better life for future generations. So this legislation will empower localities to build stronger neighborhoods where all residents have the opportunity to thrive together. Thank you.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We strongly appreciate the intent of the bill. We need more affordable housing, and we ask that you support the bill. Thank you.
Mr. Chair, Randy Grunbein representing the Virginia Manufactured and Modular Housing Association. We thank you for the amendment. And we also say that this bill promotes creativity for the localities, and we like the idea of them being creative in their zoning. Thank you.
Mr. Chair, Brian Kosa with the Virginia Housing Alliance. We support the bill.
Mr. Chair, Troy Garrett with the Manufactured Housing Communities. We support the bill.
Erin Corman with the Realtors. We also support the bill.
Anyone in opposition? All right, money talks. This is certainly an interesting way to incentivize changing in our zoning laws, and the committee has already heard a motion to report and refer. Is there a second? Second. All right, it's been motioned and seconded to report and refer this to appropriations. I would ask the clerk to open a roll for the vote. All right. That bill reports on a 4 to... Lost our quorum, so here's what we're going to have to do. We're going to take this bill by for the day with the motion.
I was trying to save you from losing everyone. If we can go at ease, I do know Delegate Leftwich is on his way.
Actually, with 5 votes, if you hit your green button, that vote. All right.
Okay.
Somebody double check me. We're going to hold the roll for just a second. Is 5 a quorum of 8? All right, that's what I thought. So we do have a quorum, and that bill is going to report on a 5-0 vote. Just as a bit of housekeeping here, we have several bills left on the docket. House Bill 2046, 2048, 2058, 2075. I would entertain a motion to pass those by for the day.
So moved.
All right, it's been motioned. Is there a second? All those in favor say aye. Those bills will be passed by for the day. Thanks, audience, for hanging in here. Members, appreciate your patience. This committee will be adjourned.